Good evening, and thank you for finding the time, making the time to be with us this evening. My name is Amy Bach. I'm the Executive Director of United Policyholders and one of the founders of the organization. We're so pleased to be able to bring you the information and the expertise that we will be sharing tonight on the topic of strategies for settling. This is one in a series of workshops, webinars, events, clinics that we have been offering to the two communities that you are in, either the folks that were impacted by the 2021 Marshall Fire in Colorado and or 2020 wildfires in both states, California and Colorado. If you want to follow along, this tells you where to go on the website to find the deck that we will be going through tonight, so you can read the slides as we go through them. A reminder that we're a 501c3 nonprofit. We are based in California, but we work around the country, particularly in areas where there have been disasters and people need neutral. They need a friend in the insurance business in a way, and we don't sell our services. We are a traditional nonprofit in the sense that our audience are who we serve are people who have bought insurance and now need to get the full value of what they paid for. We are funded by donations and grants, and we've been doing this work now for 31 years. So what we call Team Up includes our professional staff. I've got with me tonight Valerie Brown. Those of you who are in the Marshall Fire might know her from seeing her at a live event or previous webinars. We also have Carolyn Winter, who was responsible for compiling all the questions all of you submitted in advance and making sure that we were prepped to answer them. Also part of Team Up are our partners in the nonprofit community, but also our volunteers. And I have four of those with us tonight. Consumer-oriented professionals, and what supplements the knowledge and expertise of consumer-oriented professionals who are active in assisting disaster-impacted households are our survivor volunteers, people who've been there, done that, and have picked up some pearls of wisdom along the way that we then share with you. Tonight's panel is all professionals and our staff, but again, a lot of the materials that we reference on our website and some of the strategies for settling that we'll be talking about come from the real life experiences of people like yourselves who went into the tunnel and came out on the other side and have good ideas for what worked for them, and also some of the things that didn't work for them. Tonight's program is part of our Roadmap to Recovery program, but everything we do is connected. And so some of the obstacles that you're encountering are problems that we're trying to help solve through our advocacy work. And so it kind of fits together because some of the challenges that you face are very hard to solve on the ground, because insurance policies, as you know, are legal contracts, even though they don't get sold to you that way. Little bit of quick fine print. We're just here to give you guidance, even though we have 2 lawyers and 2 public adjusters here. We're not here to give you professional advice. We're here to give you information. And if you feel like you really need legal advice, we encourage you to contact any of our speakers or any of the sponsors that you will find in the Find Help directory on our website at uphelp.org. So I've already introduced myself and Val Brown and Carolyn, but with us tonight, I'm so pleased to welcome Chris Rockers, who actually had is it Chris, did you get back? Are you with us? No, okay. Chris is having some technical difficulties, so he hopefully will be joining us soon. We have Denise Z, an old friend of mine with the Greenspan Company in California. Denise has the distinction of being both a lawyer and a public adjuster. Natasha O'Flaherty with Never Summer Law, Colorado, and Stacy Tucker with Cantor and Cantor. I'm going to zip through these bio slides. That's me. And I've been an insurance consumer advocate since 1984, and I've been a lawyer since '89, and then helped start UP in '91. So I have a lot of miles on my odometer dealing with the very issues that a lot of you have brought tonight with your questions. Chris, who hopefully will be with us momentarily, very experienced public adjuster and has been a great friend to our organization. He just has a habit of always saying yes when we ask him to do things. That's what we like in a volunteer. There's Denise. Denise has had 16 years of experience litigating claims and really digging into the mechanics of how do you go from standing at your lot in the ruins of your treasured home and possessions to being back in a home that you're comfortable living in. And there's a lot in between those two of a very technical nature. So somehow Denise made the decision to migrate from litigation. I certainly understand why you might have done that, Denise, but thank you for being with us.
Happy to be here.
Stacy, 20 years working at white shoe firms. I sort of think of that as fancy. Maybe you want to just explain, Stacy, how you migrated from the defense side to the plaintiff side.
Of course. I spent the first 15 years or so of my career representing the representing the insurance companies and handling their litigations when they got sued. And a few years ago, one of the opposing counsel I worked with regularly, Glenn Cantor, said that he kept telling me that I should come work for him. And Glenn Cantor is a wonderful man, but he kind of just says things sometimes. You never know if you can believe him or not. So one day I said, "Are you serious about that?" And he said, "I could be. Let's talk about it." And the rest was history. I wanted to be feeling that I was helping people more. And this gives me the opportunity to do that.
Well, I know from experience that understanding how insurance companies make decisions and why, and what you can do to influence those decisions is a very valuable skill to have as a professional. So some of the most potent policyholder side lawyers came from the other side. And so we're glad you made that switch. Natasha, I think you were not an insurance geek, but somehow you made that migration. And if you want to just give us a little introduction of how you came to be with us tonight.
Sure, and gotta love the frozen in time photo. Like Stacy, I wanted to help people more. I lived here in Grand County when the East Troublesome Fire hit the evening of October 20th or 21st, 2021. And as a lawyer that had a background in contracts, when people started calling the night of the fire, when we knew there was a dramatic loss, I was like, okay, that sounds pretty straightforward. The handful of companies adjusted really well. And then it became clear to me that not everyone is handling the claims the same. As you know, Amy, with your help, I brought some ideas forward in Colorado to Representative Amable and Bob Rankin, and there's been meaningful insurance reform as a result for future fire victims. I do use that legislation as a best practices argument to try move some of these last ones to closure in the new Marshall Fire client. So very much like Stacy, I just wanted to help people more and thought this was an interesting turn. One of my paralegals was a fire victim who I had helped. She now got her paralegal certificate and is a wonderful advocate. And I built that part of the firm up to handle these two fires and then going forward, because like in California, our climate has changed. So that's why I came to the table.
Okay, well, we will have a chance to really talk a little bit more about strategies as we go through, and I think you know, certainly Denise, you know very well how each claim has its own kind of, you know, snowflake
Own
quality.
life. Yeah.
Right. But some of the threads that we see over and over have to do with leverage. Yeah. And how the policyholder is asserting their leverage. And so since I gave the other gals a chance to, you know, if you want to just sort of add anything about your perspective on strategies for settling, well, happy to hear it.
Sure. I think each claim has its own life. It's everybody's claim is different, and nobody knows their claim like whoever suffered the loss. The insured knows their own claim better than anyone. So coming into this, it's being able to adjust a claim as a specialty and know how to move a claim forward is something that a lot of people don't ever experience in their life, and hope that they don't. And when they're in that situation, I think it's finding different ways, whether it's going up against when you feel like you've hit a wall, whether it's finding help through an attorney or a public adjuster, or deciding that it's now time to see if the insurer is willing to go through a white waiver, some sort of settlement, potential settlement, and present your claim in a different way. Getting claims counsel involved is a possibility, but there's a lot of different tactics that you can take at the time of settlement.
Yeah. So, and just, you know, this is, I'm on this landing page here for the Marshall Fire Help Library, just to remind all of you that UP is agnostic on litigation. We're not pro litigation or anti litigation. We're pro settlement. We want to give you all the tools and information that we can give you to get the full value of the protection that you invested in when you bought your insurance. And obviously the ideal is that you don't have to file a lawsuit. You don't have to pay a professional for help. But in a lot of situations, people find that they do. And so, you know, here we are in mid-August. And so, you know, some of you have been on this journey since last December. Some of you have been on this journey since the year before. So wherever you are in your journey, the idea for tonight is to help you break through some of the log jams that are preventing you from getting through the tunnel, at least in terms of settling your insurance claim. So when we talk about settling, we're talking about settling your insurance claim more than settling a lawsuit. But because settling your insurance claim sometimes requires you to access professional help and sometimes requires you to put a lawsuit together, we want you to understand the full lay of the land. But just so that you all know, the whole purpose of our program and everything we do is to help you get what you already paid for, right? Get the, what we call in lawyerese, indemnification, basically put you back where you were before your loss, with the funds that your insurance policy should generate. So we know the process is a lot more complicated than it should be, but we do everything we can to illuminate it for you, to help you understand it. So the libraries that we set up for you, this is the one for those of you who lost homes in California in 2021, 2020. These are all oriented to help you be your own best advocate to the extent that you can. And then when you hit a wall, to know where to go to get trustworthy help, you know. And so we're going to cover today some of the laws and regs in your state regulations that give you your settlement leverage. And again, we're just talking about your ability to get the insurer to do what you need them to do to pay you the money that you need them to pay you. That's what we're talking about when we talk about a settlement. So there are options for doing that: negotiation, mediation, something called appraisal, hiring a professional to stand in your shoes and be your bulldog, and or your advocate, your negotiator, as it were, and then of course litigation. We're going to go through the pre-submitted questions. Thank you to all of you who submitted them. We'll recap some helpful resources, and we won't, I know it's hard, we're not giving you a channel tonight to ask questions on the fly, and that's because we got a lot of questions pre-submitted. And so we wanted to make sure we went through all of those. We will be doing another workshop in September on the 14th. You can go to our website, to the events page, and you will find the date for that. That's going to be another Q&A. We're going to have experts very much like what we have tonight. So if you didn't get your question in advance and you didn't hear an answer that helps you, you will have another opportunity. You will also have the opportunity to use our Ask an Expert forum. So I'm stuck on a slide that is very important. And I think, you know, this is one of those messages that can be really hard to deliver and hard to hear, because if you are having trouble and if you've had multiple adjusters, staying polite with those adjusters can be really hard. And maybe feel ridiculous to you. Maybe you feel like at this point, for crying out loud, you know, etc. But because insurance adjusters are people, and because they, even though they're not supposed to ghost you, and there are all kinds of regulations on how quickly they're supposed to respond, you know, if you get into an adversarial relationship with your adjuster that's assigned to your claim, it's never helpful. And in terms of getting what you need, polite assertiveness is our recommended approach. And that doesn't mean you're a pushover, but it means that you keep it businesslike and you keep it polite as much as possible. Try to keep emotion out as much as possible, but be assertive, right? You are the squeaky wheel that's going to have to get paid. Knowing your rights, always very important. That's what we're in the business of trying to help you do. 3 primary sources: your state's insurance laws, your state's regulations, the language in your specific policy. And then this 4th thing, the covenant of good faith and fair dealing, which basically gets read into the policy as if it were written in black and white. And that is basically that the insurance company is going to behave reasonably, and they're going to not do anything to deprive you of the benefits that they are contractually obligated to pay you. So that's basically, you know, bad faith. You hear it kicked around. It's unreasonable conduct is really what it is. So it's not like a black and white. It's very dependent on the circumstances. To get more information on your rights in California, this is where you're going to go on our website. This is where you're going to go for Colorado. We have a map in the state-by-state help section where you'll find your regs and laws. And we always remind you how important it is to keep a good paper trail. And that is because if you go to one of these professionals on our panel, they're going to want to see, one of the first things they're going to want to see is the history of who said what to who. What letters did the insurance company send to you? What letters did you send to them? What emails? What kind of notes do you have? What went down up until this point? It's always very, very important. So keeping that journal is so important. This is just that reminder again. You know, if you were at any of our early webinars, you've heard me say, or you heard other people on the team say, you know, you get more flies with honey, and you know, these adjusters have way too many files assigned to them to really do a great job on any of them a lot of the time, which means they often don't remember some of the specifics of your situation, even though they should. That's why you want to help them by making their job easier, by being very concise and not, you know, avoid long paragraphs, avoid run-on sentences, because they don't have a lot of time. So you want to be right to the point. This is what I want. This is why I want it. Excuse me. Obviously, you have personal leverage, as we lay out here. And these are some of the things that people have. These are points that you can make to your insurer whether you have special circumstances, and also confirming your cooperation is incredibly important. I'm sure that Denise has had many situations over the years where a client has been great, but they got irritated at some point and said, no, I'm not gonna let you come to my house a fifth time. Denise, is that, I see you shaking.
That happens pretty often, especially people that said, you've already gone through my house. You've already paraded, contractors, hygienists, everything else. I don't want them coming back into my home anymore. They should know it by now. And usually I tell them they need to cooperate with the carrier. I mean, that
Right.
there's a duty of cooperation with the carrier that you have to have.
And Stacey, when somebody has not, when there's evidence in a file, and this is like, if you can go back to when you were on the insurer side, that's one of the great gotchas, right? Where when the insurance company can say, oh, this person may look righteous.
Exactly. If you don't cooperate, you are giving them a reason, a legitimate legal reason to deny your claim entirely. So not only can you not catch them for handling it so poorly in a court, if it, God forbid it ever gets to that, they would have a completely legal right for having failed to pay your claim, because it's part of the policy, and the policy is a legal contract. You have to cooperate. And yes, they're being unreasonable, and they probably know they're being unreasonable, but it's still a legal requirement. So you just you're really cutting off your nose to spite your face when you refuse to go along and jump through their hoops. It's annoying, but it's worth it. You come out looking good at the end of it.
Right. So you're always wearing the white hat, right? In every communication. But Natasha, I think you would probably say there are situations where the person, maybe doesn't need to cooperate, or can establish that what the insurance company is asking them to do is just not reasonable.
Correct, but I agree with the other comments. Absolutely, be cooperative. They have a duty to act in good faith to effectuate a fair and reasonable settlement of your claim or payment of your claim. That being said, when I have clients coming in, mostly now that the people are at the 2-year mark, where the clients can't give what they don't have. And I find it unreasonable when a carrier says, well, we'd like you to go back to all the people from whom you bought your furniture, have them reissue sales receipts. You have to give them what you have. If you don't have it, it's okay to say you don't have it. Those type of requests we do push back. I find those to be excessive. I'd be curious, kind of your take on that, Denise, of when they're asking for something that's so time consuming and unrealistic that most vendors would even produce. I do draw the line on some of those requests.
I think we draw the line on that quite often. If there's something that just is easily obtainable, they can go on to Amazon and download a bunch of receipts, then so be it. We get those out to the carrier. But when it's something that they have to go back for so many amount of years, let's just say, I've got clients in the past that have said, look, I paid for everything in cash, and those receipts were paper receipts. It burned in the fire. You can't recreate what doesn't exist anymore. And that's what we let the carrier know when it does. But there is a certain amount of things that the carrier may ask for. They may ask for, personal information, and people feel that it's not warranted, such as maybe they would ask for your phone records or something like that. And there are times that I know it's burdensome, but I encourage my clients to go ahead, produce what they have. You have nothing to hide. Let's present the claim the best way that we can.
Yeah.
I think the one thing I would caution here, and I see it again and again with some of my newer clients, this whole idea, you did not buy a self-serve policy. Everyone listening on this call, I'm so sorry you lost your homes, but you thought you bought insurance. And when your time of need came about, you were hoping that the carriers would be there to help you. I'm a little perturbed by this new trend I'm seeing with a number of inquiries of having the carrier want you, the insured, to calculate the ordinance and law of, okay, you had 2x4s, now you're going by 2x6s. It is not your duty to adjust the claim. You did not buy a self-serve policy. Yes, you have to cooperate, but just do keep in mind, the job of adjusting the claim is with the carrier.
Right. we just have I think a lot of you know, if you've been on previous programs, we've had the high level people from the Colorado and the California Departments of Insurance on our panels answering questions. And, we hear from a lot of you some frustration that, you filed a complaint and it didn't really fix the problem. Sometimes it does. Sometimes it does, and that's great. And we really want people to do that. But we want to remind you that, if a lot of people are worried that filing a complaint with the Department of Insurance is going to get them in trouble, that the adjuster is going to be mad or the insurance is going to be mad at them and treat them worse, and that it would be illegal if that happens. That cannot happen. I think the main challenge is that these departments of insurance cannot be your free lawyer. They cannot be your personal public adjuster. They can only try to put as much pressure on the insurers as they legally can. They often say they use the bully pulpit, and they also have penalties. Natasha, you've been really successful on helping some of your clients get penalties from the Colorado through the regulations in Colorado. Can you just tell us how you did that?
Sure, it's in the slide deck later, and I would strongly advise those on the call to look at that. They have a duty to pay a fair and reasonable estimate of your claim in a timely manner when they have a complete claim. The age of the dog food is not essential for a complete claim. The penalty payments are 8% for amounts paid late.
Just Colorado, by the way, not
Colorado. And forgive me to my—
No, it's fine. I just want to make the caveat.
Colorado. These amounts are not insignificant. They range from $50,000 to well north of $200,000 of additional monies. This is not part of your policy limits. This is additional interest penalty payments on top of it. And if you're really, I assume a lot of you are on the call because you have hit loggerheads. I think where the complaints to the Division of Insurance are really helpful is there was a series of behavior with a carrier that I really wanted the division to be aware of. I think when you bring this forward, it might not just be your claim, and for the division to effectively not just help with yours, but help establish a practice that's not appropriate and initiate a market conduct investigation, which in the end will help your claim. Do speak up. It's quick in Colorado. It's an email link. You can add some documents or pictures if you want to support your arguments that you make, but it is helpful for the division to know if carriers are not playing by the rules or not honoring their contracts. And again, those penalty interests are not inconsequential. Under 702, again, my clients range from tens of thousands to hundreds of thousands.
And this is without having filed a lawsuit. You can get the penalty interest even though you haven't filed a lawsuit, right?
Correct. These are just on amounts that were paid late.
Okay. All right. So we're going to take a deep breath here for everybody to relax shoulders and increase the blood flow to the brain and try to digest some of what we've already kind of been kicking around. Okay, we're just very briefly going to go through these because we want to get to the questions, and also because you have the slide deck and you'll be able to reference these. This is one of the very common problems people have in their claims is over depreciation and how much the insurance company has depreciated the value of all aspects of their property loss, so their dwelling, their other structures, and their contents. So this is just to let you know that in California, it's very clear in the regulations that the condition of the item matters, not just the age. And I don't think you have that clarification in Colorado, Natasha, right? There's no—
Not by statute, but it is certainly what we address in 100% of the clients we represent.
And also that the insurer should be telling you how they depreciated.
That is required in Colorado. They must provide their method of depreciation. And anytime you're seeing something more than 30%, absolutely challenge it. the example I give that's, I think, applicable so often is, let's say you have Waterford crystal from your wedding. I've been married 22 years. It's in my cabinet. We use it. It has no chips, no nicks. So by their depreciation schedules, they would maybe pay me 10 cents on the dollar. The reality is it's in like new condition. So absolutely condition matters. And if you see excessive depreciation, you do have the right in Colorado by statute for them to provide the methodology of how they got that. And it's not unusual to cut that depreciation in half or more once you challenge it.
So, yeah, so what we're doing here, we're just highlighting a few things that are notable in the laws, and also just sort of in that relate to your leverage. So a lot of you are suffering, maybe all of you, with your inventories. Your contents inventories is definitely one of the more painful aspects of the process, although there are so many that it's hard to rank them, but this one is definitely very painful and frustrating for a lot of people. So as you probably all know, well, our organization and a lot of our friends and volunteers have worked really hard to get legislation through that would reflect what we all see as the reality. Well, the insurance company collected a premium from you for a set amount of contents of personal property. All your contents are gone, so why aren't they just cutting you a check for the policy limits in that category? But we have gone many rounds arguing with insurers on that and not really been able to win in the legislature, but we have tried lots of different things. So in California, the commissioner has used what he calls the bully pulpit, and also kind of peer pressure, I guess, is sort of what it is, to get insurers to do things that they otherwise don't want to do. So in this situation, the commissioner in California said, okay, let's, we have the same thing you have in Colorado. 30 in California, 30% is all they have to advance as of your fires. Starting on August 9th, any fire in Colorado after now, the insurers have to offer 65%. They have to at least advance 65% of your contents, but because, as you all know, and it's very painful, it doesn't technically apply to Marshall Fire people, we are doing everything we can to try to, with the Department of Insurance in Colorado, to pressure insurers, even though the law doesn't technically apply, they should honor it. There's a lot of good reasons. This is what the California commissioner did, and the Colorado commissioner is really following suit. It's just basically to call out the companies, to praise the companies that are offering, that are not requiring meticulous itemization or that are at least agreeing to advance contents funds without an inventory. So that was just an approach that that was taken in California. Colorado is also sort of doing a similar approach. We were on a call with the Colorado department this morning, and they I didn't even touch my computer and it just started moving. The Colorado division has said that they are in active negotiations on behalf of Marshall Fire folks to get insurers to voluntarily tender the 65. A lot of insurers are agreeing to 60. So if you're in Colorado and your home was destroyed in last December, then you should absolutely be asking and be for at least 60% on the basis that we know that some insurers are doing that without requiring inventory, and then to get the rest of your benefits, you still need to itemize, and you need to replace things in many situations and then submit the receipts. So in California, you have 36 months to do that, to get the difference between whatever the insurer has advanced for contents and what your limits are. In Colorado, we don't have that law clean yet. But again, the spirit is what the law is going to be, which is that you have up to 3 years to replace contents items, give your insurer the receipt, show them that you spent more than what they paid you in ACV, and get reimbursed. These are the Colorado claim standards that are in place. Natasha, we highlighted number 4 there. Is that something that you use a lot?
Yes, absolutely. And I would encourage everyone on this call to use this. And it relates to a number of the questions that are coming up. Your carrier cannot just put their head in the sand. If you have a rebuild contract that reflects actual cost of labor and materials, they can't ignore it. They have to investigate. They cannot just rely on their software in adjusting a claim. And then if I could go back for 2 seconds, Amy, on the contents. When you're doing that really painful inventory, if your carrier is making you do it, again, not all do, but if you have to do that, make sure that when you submit your contents list, keep counting. Don't just hit your policy limits and say, oh my God, that was excruciatingly painful and time consuming. First of all, add links if there's unique items. If you found them on an auction site, take a screenshot because they may disappear. I encourage the clients to keep counting until they get to at least 150% of their coverage. The goal and the way that's paid is that you have your replacement cost minus depreciation is ACV, actual cash value. That's what they'll pay you now. So rather than going down the crazy rabbit hole of receipts, most people I see have far more contents than they had coverage. You can avoid that piece of the brain damage if you're just willing on the front end to keep going on that list. United Policyholders has a great template. But if you can make sure your ACV payout is at limits, you don't have to worry about submitting a receipt for your new toaster line item 9,173. There's a reason during the hearings that the commissioner asked State Farm to own up to how much they pay on average for contents, and it was 37 cents on the dollar. So if they put enough hurdles up, you get to avoid payment. But again, just keep counting till you're at 150%.
So thank you. And we had a little switcheroo, and we were joined by instead of Chris Rockers, he had technical difficulties. We got the guy who taught him a lot of what he knows, who's joined us, Scott DeLuise, not named properly quite yet in his window. But Scott, thank you so much for joining us on the fly to help answer questions in related to the rules, regulations in the state of Colorado. Thanks for joining us. We haven't gotten to the questions yet. We're still kind of we're on the we're just highlighting some of the regs and rules that are most useful for people. Thanks again for joining us.
Glad to be here.
Okay. All right. Another Colorado bulletin that I think we decided is worth highlighting. Your insurance company cannot require you to have your property repaired by a specific individual, excuse me, or entity, or require you to travel an unreasonable distance. Scott, do you use this bulletin?
You were a little bit fuzzy at the end there, Amy. What's the question?
Do you use this bulletin here that reminds carriers that they cannot direct which remediation company is going to do the smoke remediation, or which what builder the person's going to use?
Yeah, we do. It's called steering, and insurance companies do this at great peril, because if something goes awry, they will be held accountable and responsible, maybe not by the Division of Insurance, because bulletins are not enforceable by law, but if you end up in litigation or you have somebody helping you with your claim, they can use it as leverage, or you can use it as leverage to get your claim settled.
Yep. Okay, we're going to zoom through because I really want to get to the questions. There's some more bulletins here, but like I said, you all have the slide deck. So you'll be able to go back and reference. These are we have highlighted the ones that we think are most important, most useful. And to you, these are our links for people in Colorado to websites that have information that you may need to get to the settlement that you're looking for. And that includes links to the building codes in some of the counties if you are in a situation where the insurer is trying to say they don't owe you for code upgrades. So what are your options for settling? Using our resources to get a settlement on your own, to politely and professionally remind your adjuster of what their obligations are, and then to provide proof of violations to the Department of Insurance. Okay, mediation would be something where you get down the road. Actually, why don't I just have Stacy? Stacy, what can you do in a mediation?
Mediation, as you noted, it's informal. It's a way to bring everyone to the table with ideally a neutral third party to help mediate between the two and discuss what the issues are, what each side's perspective is, and can often suggest ways to compromise in a way that works for both parties. It's not litigation. You don't have to agree with it. You don't have to take it. You can say no, thank you. But it lets you hear the other side's perspective and lets them hear yours in a way that's less combative. And it can often result in all parties agreeing to a resolution instead of continuing the back and forths, which so often aren't productive. Just the yelling or email yelling back and forth with each other and not resolving anything. And because it's not required, as this slide notes, there's always the possibility that the insurance company may not be interested, may just be there to check a box and say, okay, well, we did it, now let's move on. And the mediator, depending on who selected the mediator, may be a shill for the insurance company. That doesn't have to be the case, but if it's someone that the insurance company hires over and over again, they have a vested interest in representing the insurance company to get hired yet again. So be aware of that. However, it rarely hurts to participate in it if it's offered, and you can certainly also request it. It's also an option during litigation as a way to resolve a litigation. It's just another way to try to resolve a dispute. It rarely hurts. It can help. I'll be honest, I don't see it helping very often in pre-litigation, but it's always an option. It's another tool in your toolbox.
Yeah, and in California, there is a free mediation that you can do through the Department of Insurance. That is not an option in Colorado. Appraisal, we're not really going to go into it right now, but it is a process if there's an argument over the value of the rebuild or that's primarily what it would be used for. We have good information about appraisal on our website, kind of breaks it down. I've never known a policyholder to go through appraisal without a public adjuster or a lawyer ever. So,
and Amy, if I can just add something on mediation, I deal with mostly everything pre-lit nowadays, and very rarely do I go to litigation. I'm working on the public adjuster side. So mediation, I actually think is a great tool. I know it's a perspective, but it's also the fact that my clients have a public adjuster that's going to guide them to the mediation, that's familiar with the mediators, can help choose the right mediator. In fact, we find that if we are at a specific standstill, there are a lot of times that we will request mediation, that we'll request that claims counsel for the carrier gets on, and that we get into mediation, And if claims counsel is willing to go to mediation, usually they're willing to settle for a number. Whether or not it's one we agree on or not is remains to be seen. But a lot of our cases that are at a big standstill, we actually get resolved in mediation.
Yeah. So, so I guess I should ask, and these are the different types of litigation that you can be part of if you decide to go that way. You can do an individual case. You can join if you're. There's a lot of people who are underinsured that are looking at getting into a group lawsuit with other people who are underinsured. Those are just options. And all this information you'll find in our library and lots more. I guess before we leave this section, I want to ask Natasha, have you, you're a practicing lawyer in Colorado. You don't have the same Department of Insurance mediation program that we have in Colorado. Do you, when you have resolved claim problems for your clients, for wildfire impacted clients, have any of them been through mediation, or have they all been through informal conversations?
Right now, it's just going through the claims process and enforcing the contract and enforcing the regulations. We've not had to take one to mediation. That being said, I had a new one come in. On this one, I am going to suggest it. But normally we've been able to just work through the contract and go through the traditional steps of getting the claim paid up.
Yeah, same, Scott, same, right? No, you don't, you just go, you get into the negotiations and there's no kind of proceeding that you're negotiating within, like a mediation, right?
Well, that's exactly right. And by the way, hello to all of my friends in California and Colorado. Denise, nice to see you.
Good to
Natasha,
see you.
nice to see you. And thanks for inviting me. In Colorado, appraisal has turned into a nightmare because carriers are using it as a tool and a cudgel to beat up policyholders. We're very careful entering into the appraisal process now, and it looks like mediation is going to be the go-to because we can assist our policyholders in bringing in somebody that really knows the bad behavior of the carriers, i.e. a mediator who's typically a lawyer or somebody with that kind of training, and the results seem to be better. Appraisal just leads to litigation in Colorado, it seems.
Yeah. I'm sorry to hear that. The idea was it was supposed to be cheaper and faster than litigation. Okay, let's all take one more deep breath and we're going to dive into the questions. Okay. Kimberly in Colorado is talking about a topic that has come up a lot and always comes up a lot after wildfires, where sometimes it feels like it's easier for somebody to get a fair claim settlement with a total loss than a partial. We did a 4-part series earlier this year on partial losses and smoke damage. And so if you didn't know that and you didn't watch any of them, I would encourage you to go to our website and take advantage of some of those, watch some of those videos and hear from some of the experts that we curated. So Scott, this one was assigned to Chris. So if you want to take a minute to read it before you help us get an answer. So we've got a combative adjuster. Damage has been downplayed from the start. That's classic. Environmental hygienist found soot, ash, and char inside the wall cavities and called out that the house should be gutted to the studs. The adjuster started balking at even the most basic painting, and now they're in kind of a battle between environment hygienists. and testing. What's next to move forward? We don't even know what questions to ask.
That's a great question, and frankly, that's coming up more and more in our Marshall fire losses. It didn't seem to be as big an issue in Grand County, but we got most of those either settled, or we have a couple of them in litigation over this issue. The bottom line is that you cannot give up, and if you're documenting your communications with the carrier, this is basically a fraudulent activity on the part of the policyholders. And I want to point out my sweatshirt here. I'm a member now of the American Policyholders Association, and we're not talking about policyholder fraud here. We're talking about insurance company fraud. Amy knows all about it. Denise knows all about it. Natasha knows all about it. But insurance companies have been engaging in insurance fraud for years and years. And if you properly document your claim and you get to a point where you cannot get the insurance company to move, you've tried the Department of Insurance by filing complaints about the insurance company's behavior, just hang in there, and eventually you will prevail based on the damages. I guess my biggest question back to Kimberly, who asked this question, is the insurance company saying that your home is habitable? Because you can't live there. And if they're either cutting off your additional living expense or saying that your property has continued to be habitable after this damage, you've got a big case, and you probably need to get ready to document it to the point where you can hire an attorney.
So, Denise, even though you're California, this is the same game that gets played in California and is getting played
Absolutely.
throughout your area. So you've got warring experts. How do you move forward?
I do a lot of documentation and writing, because the fact is repetition to show that you're submitting and resubmitting. Showing photographs are a really great thing, especially if you have smoke, soot, and ash between cavities. And then I try to elevate the claim. If you reach a point where that adjuster is just not doing it, where they're not responding, or they're just downplaying it to a point, I start raising it to management at that point and submitting my expert reports, showing that I've submitted it multiple times, and I go that route. If there is a big problem, not that we kind of touched on it, it doesn't do the best, but sometimes we will recommend that our clients actually submit a claim through the portal for the Department of Insurance. So that's another point of documentation. Not that you want to document for a lawsuit, we want to settle it, but when they show that you're making those steps towards potential documentation for a lawsuit, sometimes that does bring them back to the table to actually settle.
Yep. Okay. This one's for you, Natasha. I received a lowball estimate. It's been over 60 days. What's the likelihood they'll come back with a reasonable offer?
I love Stephanie's optimism. Let me just pivot back. I know so many people on the call are with Marshall on that last one. I think I concur with the comments, but on the smoke damage, I think the really good pivot is talking to your neighbors. So many, because the fire was so narrow of how it hit, so many of you have smoke damage, but many of the carriers have taken it down to the studs, lacquered the studs, taken out all soft goods. So to me, you also established what are the best practices and how are the claims being handled. Smoke damage is very much the hallmark of the Marshall fire. And it's such a blatant violation of 1104. So sorry to digress. Stephanie, you are asking the question that I have seen for a year and a half from the East Troublesome fire. And certainly, again, not as severe, but definitely consistently on most of the Xactimates. Most insurance companies use the software. I don't think they're going to come back just with a reasonable offer. Very much along the line of what Denise was saying is come back. You can do a couple things. Generally, if you're planning on rebuild, submit them your rebuild contract. That contract reflects the actual cost of labor and materials in your area. For some clients, I highly encourage them to submit their own Xactimate. You can request the ESX file from the carrier. Most carriers are more than willing to do that. That gives you the detail of what you need. So that's going to help reconcile. They really do like staying in their Xactimate language. But again, your rebuild contract, your own Xactimate is going to cover that difference. And I suspect the difference with the current rebuild costs in Marshall, that difference might be more than 200 grand with the cost of labor and materials right now. So I hope that's helpful. Those would be the first two steps I would look at.
Thank you. Okay, Denise, how to know if you've been paid all the money you owed for contents? How do I get the full insured value for my personal property? And then the second part of the question is how do I know if it's similar, right? How do I know if we're getting a fair payout?
Wait, we touched a little bit on this earlier, but when it comes to contents, the first thing is knowing your policy. Know how the policy is a contract, so you do have a contents limit. Know what that contents limit is, and then also check other portions of your policy to see if there's extensions. Sometimes in the event of a total loss, or if your loss is at a certain point, that there'll be policy limit extensions that will, or inflation guard, that will actually help you extend that contents limit a little bit. That's happened in some total loss cases for us. So what there is, we do contents in a very specific way at Greenspan. And I think the reason is that we try to dig out every penny for you, even down to, if you look at down to everything that's in your home you've accumulated over time, it's down to the toothpaste, it's down to the toothbrush, things that people don't normally think of high ticket items. So we add everything that we can. We go through memory lists. United Policyholder has a great link for that. And we go through and add ages, conditions, and the other thing was we have a whole contents team. So what they do is they add links. They find a comparable product to what it is that you have, some piece of contents that you owned. And then we go through and we try to price everything out. Now, Natasha earlier said, bring it up to 150% if possible. We touched a little bit on ACV versus RCV, which is actual cost of value versus replacement cost value. In most contents policies or will give you replacement cost value, but at first they want to give you actual cost value. That means the amount of depreciation is taken and they give you the actual cost value of the item. So look and see where they've depreciated and so forth. And when you replace the item, you submit receipts and they give you the depreciation back. But in events like fires where there's a total loss, you want to get above and beyond. So what we've tried to do is we've actually tried to document everything in the house. It's beyond the 150%. It's beyond the 200%. A lot of people are underinsured and under their policies when it comes to an event of a total loss. And that we found that, and this is just to lead in to get everything back for contents down the road. What you might want to think about is a lot of our clients in wildfires have then participated as underinsured or in subrogation matters, and they've used our contents list afterwards. And now, since we've documented everything down to, your last paperclip, if possible, then the insurer is more likely to pay out your contents limit. And then anything above and beyond that, you might actually be able to obtain in other litigation if that's a route that you choose to go. I see that there's this question about personal property payouts. They touched on this a little bit earlier, but there was basically Gavin Newsom signed in one of the Senate bills. It was 872. And I think it went into effect in July of 2021. And it basically told carriers that they should really pay 30% upfront up to an amount of $250,000 for contents. And I know that State Farm did that, a couple of carriers did that, but a couple of carriers went above and beyond and went farther and paid up to 75% in some instances in some wildfires that we had in Woolsey. So I think that your neighbors might have gotten something, paid something different because literally due to the fact that they had a different carrier.
Yep. Okay, overpayment. This one, Stacy, I've got tagged for you. We've got two parts to this.
This is kind of the opposite of the question we just looked at.
Yep.
And in this situation, the nice thing is if they've chosen to give you a lump sum advance payment, they're not in a position to claw it back. So what you can do in these situations is just close your claim. They chose to pay a lump advance sum, partly because it's required by the insurance code now. As we talked earlier, previously insurance companies were asked to pay at least 30% upfront. As of 2021, for fires that happen after that, it's now a required minimum up to $250,000. So they're not over analyzing it right now to try to claw things back. It actually, in some respects, just like it's a huge pain for you to put together any sort of laundry list of items, it's a huge pain for them to have to try to micromanage and figure out, okay, who do I have to claw back from everyone? So in these situations, the best way is to just close your claim at that point. Each claims adjuster right now has potentially hundreds of claims on their plate. They are not laser focused on you, as you've probably noticed. So this is a place where you can take advantage of that and just close your claim and move on. However, make sure that you really have gotten everything. You may have gotten new couches, new beds, but did you think about all the stuff that was in your junk drawer that you need? The forks, the weird ladles, all of those things are gone. And if you want to replace them, this is your opportunity. But if you're happy with what you've gotten and you just want to move on, yes, you can absolutely close your claim. Amy, you're muted.
Sorry. Okay, our Colorado folks, State Farm keeps putting stuff in the wrong buckets. I'm sure Natasha and Scott, you've never had this problem for a client. I can't get answers on what coverage is for trees and shrubs, and they say they no longer give out certified copies. So let me start with Natasha, you take number 3, and then Scott, you take 1 and 2.
All right, well, it's funny how State Farm keeps popping up as the offending carrier. Actually not funny, but it's the reason we were able to, in conjunction with Natasha and Amy, get a new law passed in Colorado that really helps policyholders. This is a typical State Farm tactic where they estimate your replacement or your actual cash value. Your replacement cost is over policy limits, but your actual cash value is less than policy limit, so it does not trigger the debris removal extension on the dwelling. It's a very intelligent way to underpay claims, but again, insurance fraud on their part. We'll see how that develops as we're getting to the point where we get into litigation. Exactly the same issue with landscaping and debris removal. Obviously, your debris removal has put you over policy limits. They're not required to pay the debris removal expense for contents and those extensions of coverage unless you are over policy limits, wherein the 5% extension for debris removal applies. If you can't get answers on what coverage is for trees and shrubs, all you have to do is refer to your policy, in my opinion. Now, I don't know the details of this any more than what's in the question, but it seems to me that your sublimits for trees and shrubs are specifically included in the body of your policy. They should have paid that up front. unless they're trying to dodge policy limits by saying, well, we have a limit of $500 per tree and shrub. We're not going to pay because we don't think you've exceeded that. Again, insurance fraud, but we'll see what happens with that. I hope that answers the question.
Yes. Natasha, on number 3.
On number 3, it's very simple in Colorado. Your question makes me laugh, Barbara, and for everyone on this call in Colorado, if you request a copy of your policy, they have to provide it within 72 hours. Forgive me, our evening cold train just came by my office. As to a certified copy, that's just hilarious. No, they are required by statute to provide it within 30 days of a written request. Definitely request it. This whole game they play, and not only request it to be sent to you, your certified policy, because that really tells you exactly what you have. Request it that it be sent to you via email. There's a strange game that the carrier we keep naming plays. They send it to you in microscopic 4-point font. And then you want a legible copy. Don't have a paper copy because it's a strange game of, minute font. So just put it in writing. You're requesting a certified copy. You certainly can request both. There's no cost to it. They're required to do it by statute. And if I can just dovetail and say, in terms of that 5%, the underpayment, that really relates to the question that Stephanie asked of why it's so important to get a good and accurate estimate of your loss if you're going to be past your limits. How that works is, in most policies and by statute, you're getting an extra 5% once you hit limits. What Scott referred to is it's not just 5% on the house, it's 5% on the other structures, it's 5% on the contents. Debris removal can be really expensive. Up here, we typically saw about $60,000 to $125,000. So once you hit that limit, you're opening new buckets of money that are available to you. So that's why getting a correct estimate or rebuild contract out as soon as possible hit those limits. And absolutely, you are entitled to your policy.
Yeah. Okay. Denise, $200,000 difference, but underinsured. So this person is underinsured. This is a whole nother topic. Getting the insurer to bridge the gap. Do you have sort of a short? It's really not a lowball estimate. This is actually a little bit misnamed. If there's a difference between what they're being quoted to rebuild and their coverage, they're underinsured. So as far as I read this question.
Right.
So
it looks like Joseph is asking a classic adjusting question. So
yes. Okay.
And I think really that's how I take it. If there is a difference in adjusting in California, the carrier is required to be able to put out an estimate to you that for the same amount that a contractor can come in to actually rebuild the home. So if there is a $200,000 delta, your contractor doesn't want to take this. Sometimes we tell the carrier, come in, bring in a contractor that can actually do this job and call the bluff. If they're not able to do that, I mean, there are other things that they're supposed to do is actually adjust the claim properly. One of the things, the tricks that we use is that we give multiple sub bids, and the sub bids are usually what drives up the actual bid differences, and that they have to go and look at that. Now, the problem is that most contractors don't write what's called an exactimate estimate. An exactimate estimate is a line by line estimate that on a program that was developed by the insurance carriers. So if you are able to find a contractor or somebody that can help you write what's called an exactimate bid and then put in the sub bids for things that have big price discrepancies, such as lumber right now is a big item that we sub bid now because the exactimate pricing isn't correct, or we sub bid out the cabinets. There are different ways to utilize these sub bids to drive the price of the overall bid back, and the carrier has to be able to come and look at the difference and see if they can come up with someone that will do it for that price of the sub bids.
Yep. Okay. Natasha, our insurance company paid us a finite amount. And basically, this one is straightforward. We're drastically underinsured. Is obtaining an attorney the only way to do this? We've also asked if we have to itemize, and they said we have to in case we were to be audited. They were to be audited. Is this true?
I have never heard. Let me start with the second.
heard of
question
that.
first. I have never heard of that.
It doesn't make any sense.
And let's be honest, even State Farm, which was probably 95% of my workload in the last 2 years, they offer lifestyle interviews. I would be asking the carrier what type of assistance they offer for contents. They have the ability to drop down macros. They could provide assistance similar to what's on the UPH website. I agree that those resources, just that memory jog that Stacy was talking about, is really helpful. We keep one price. The other thing I say is, it's such a painful process. Grab your best friend, your spouse, go pretend you're getting married and go register at Target, Macy's, Sur La Table. You'd be surprised that most of my clients just in their walk through Target are at $30,000, $40,000. You need an ironing board, you need an ironing board cover, you need an iron, you need ironing spray. And then you just print out that inventory list or put an E and add it to your inventory. In terms of these underinsurance, that's a more nuanced question. We're having stakeholder discussions with the division of how this can be addressed going forward. Without knowing more, Robin, it's hard to answer your question. Were there communications that you requested more insurance? How did the insured amount, come to be in your policy? We are successfully getting some reformation. If it is just so obscenely low, or where there were communications requesting more insurance, typically what the carriers then do, usually does require an attorney to negotiate it, but what they're doing is if you have a basis, they will go back and put you to where you should have been insured, and you have to come back and pay the difference in premium. But sometimes it's worth it. We just got one the other day that was almost 600 grand of additional coverage. And yes, the insured had to pay, I think, $280 of additional premium. It's worth it. So that's a little more nuanced. I can't answer it without knowing more details, but it's a good question. It's one we're seeing a lot in the Colorado fires. And Scott, I'll defer to you on that one too, of how you're handling that. But
actually, we're gonna have to move on to the next question. But just to add, United Policyholders has done. We offer a lot of free resources on our website to answer that question. How does one get more money? Is obtaining an attorney the only way to do this? So I would really suggest, Robin, if you're watching, if you're signed in, that you watch one of the recent webinars we've done, specifically focused on how do you take your best shot at getting your policy limits reformed, and spend a little bit of time, use the search box on our website, put in underinsurance, you'll find a lot. Inventory detail, Scott, is it better strategy, compared to finding similar items online? Should I submit these links for pricing links? But I want to show that I didn't make the prices up. What do you think about that? Do you do that for your clients? And then on timing, is it this is just for a contents inventory. Is it better to submit the full list all at once or submit pieces as you go?
Well, this is a very good question, and the detail, what's that analogy? Something's in the details. The
devil.
Yeah. Bottom line is that the more information you can give the carrier about the cost of the items and where you shop, that is significant. If you do your shopping at Walmart, your pricing is going to be different than if you do your shopping at Nordstrom or Lord and Taylor or whatever. And the carrier needs to know what your lifestyle is so that you can get good numbers for what you purchase. Less is not more. The carrier doesn't want the information because it enables them to back up their estimate of damage, but give them everything that you can. There's no reason not to submit everything. As far as timing, you won't get above the 30% Colorado statutory minimum unless you submit a full list. So if you break it into many pieces, it's just, you have to submit your entire claim or they just won't pay. And even if you get above the 30%, my opinion is if you can afford to wait and itemize your claim with actual or adequate pricing and documentation, you'll get a better result.
Agree. Okay. And we actually say the dough is in the details, not the devil. All right. Stacy. Actually, this is a Colorado question. I'm getting a little, it might be off my schedule here. Hang on.
It was assigned to me, but it is a Colorado question. So I'm happy to have someone else jump in, but I'm guessing it's the same for everyone, which is document,
Sure
document. Be polite, be assertive, write emails, do everything in writing. Don't ever be the bad guy, but don't stop following up either. Definitely ask to speak to a supervisor in writing. Definitely ask for their email address so that you can email them. If somebody calls you, we frequently see where adjusters insist on trying to do phone calls and won't respond to emails. Email back with a summary of the conversation. Here's my understanding of what you said. Please let me know if you disagree. You want to just keep pushing forward. Also, you can escalate to the Department of Insurance. That will get their attention, and they have to respond to the Department of Insurance. So if they're ignoring you, make a complaint. They're legally required to respond to the department. So that is another way to get their attention. Each area has specific laws and regulations about how many days they have to respond to you, but everyone has them. I don't know Colorado's, but in California, they basically have to get back to you within 15 days.
It's 20 days in Colorado.
Yeah, so they're way past what they should have done for you. And I would escalate and get angry and politely angry, which is a careful balance, and follow up with the Department of Insurance if they don't get back to you.
Yeah, and this is, having been working pretty closely with the Colorado Division of Insurance now for quite a while, they have some good people on their team, and this is the kind of thing where they can help. Delays and answers and friction with an adjuster, that's the kind of thing they can help with. Okay, Denise, I'm sorry, this is another Colorado one. We might have gotten.
Okay, I saw that it was assigned.
Was it? Okay, so
yes.
I might have gotten a little off the numbers here. So, but sad to say, Colorado and California people, these things are very similar. That doesn't really matter where you are. The procedures are kind of the same. So, a classic kind of scope of damage from extreme heat and smoke, and contrasting estimates, and the policyholder wanting and needing new windows.
Right, and I
dealt with that, Denise, many times.
Yeah, no, we have, and with our wildfires also, and I see Jim and Pam actually have done everything right. You've documented, you've gotten your expert, you've shown that submitted to the carrier details. It says that you submitted details that of which windows are damaged and so forth. So I think the bottom line is that you're doing everything right. I would try to escalate the claim, and I'd make a couple of additional arguments. One is, it looks like the carrier might have conceded, or State Farm might have conceded, that you've got nine windows on one elevation, but you want to look and tell them there's a uniformity issue, that if you're going to change one, you're going to change them all because there's a uniformity for appearance. And also the other thing, I don't know how old the house is, but you might want to consider some warranty arguments. So the fact is, if there are warranties, your home is 3 years old and your windows are still under warranty, you might want to say that let the carrier know that they're not going to warranty your windows from this point on. They're damaged to a point that they can't function, and they're not going to guarantee them anymore. And the fact that you had a loss triggers now the replacement of them.
Yes. Okay, additional living expenses. We've got 2 California and 1 Colorado. So in California, 2021 Dixie Fire, how long does insurance need to pay my ALE, Stacy or Denise?
I'll take the first one, you take the second one. How's that, Denise?
There you
Sure.
go.
You need to look at what's in your policy, because your policy may have a time limit and it may have a dollar amount of ALE. If it has a time limit, under California law, they have to extend, if there's been a state disaster like a wildfire, they have to extend it to a minimum of 36 months, and you can request an extra 6 months on top of that, I think. However, they don't, if you run out of that dollar amount, let's say you have $200,000 for ALE and you've used it up after 24 months, they don't have to pay more than the $200,000. So it's important for you to understand what your total coverage is and how it's calculated. And that will help you figure out what your ALE is. And also, it's really hard when there's a big disaster because prices go sky high. You want to try to get some type of long-term living arrangement where it's the least amount of money as possible, so you can stretch out that $200,000 as long as you need it. Because the truth is, you will need it probably for at least 3 years. It takes forever to rebuild these days.
Right. And riding off of exactly what Stacy said, if you've gotten to your policy limits, there's a problem. But if you haven't gotten there and you want to get beyond that 2 years, if you are showing the carrier that you are rebuilding diligently, giving reports of your rebuild, letting them know, I've submitted letters from contractors giving a status update of why there are delays, if there's building material delays, or a lot of times the building department delays for permitting, that it stretches the time beyond the 2 years. We've done that for quite a few clients in the Woolsey fires. So if you're able to get that because you have those funds available, just make sure you document.
Yep. Diligence, and that you get the 2 6-month extensions past the 24 should not be hard to get, as long as you have some documentation that you're cooperating, going back to what we were talking about in the beginning. Natasha, how long can I expect to get insurance help for housing while my damaged home is repaired in Colorado? Let's see. You're on mute. There you go.
In Colorado, you're lucky. A couple of things are working in your favor, whether you are rebuilding your home, repairing a damaged home, or you've opted to buy a new home. Your policy, depending if you bought 12 or 24 months, typical language just says that they're going to pay the reasonable and necessary additional costs incurred to maintain your normal standard of living. And it's the earliest of your policy limits, the time to rebuild or replace your home, whichever comes first. You have a bonus here in Colorado, a bulletin, 5.42, which says if through no fault of your own, it takes longer than your policy provides, you can extend that. We talked about that earlier in the call. I would strongly encourage you to go to the United Policyholders website. Amy and I did a whole piece just on ALE. And I know the one thing in Marshall and East Troublesome Fires, many people, to maintain your normal standard of living, well, that sounds great, but there were no homes that were comparable to what you had available for rent. So we also looked in just where can you live during that time? You were not expected to go from a 4-bedroom house to a 1-bedroom condo. So take a look of what's available there. We can go past the 2 years in Colorado. We just had our first one extended, lots extended in like 3 to 6 months past the policy terms. Got our first one for an additional year. Here, I would really also focus, if you need an extension past your policy term, first focus on when did the carrier give you your estimate of loss? When did you have a budget to work with? Rather than saying just supply chain issues, labor issues, first focus on what did the carrier do that maybe caused your rebuild or your repairs to start later? So Colorado is pretty good news.
Okay.
Amy,
Alright.
quick response. Also, Colorado also put out a bulletin that said that carriers cannot use a dollar limit for ALE.
Correct.
That's very important. You get either 12 months or 24 months, but they can't say, well, you've run out of money because our policy has a $95,000 limit for additional living expense. That's not cool in Colorado. It's a bulletin. It's not a law, and it's not anything else other than
Yeah.
a recommendation.
But that is, I'm so glad you mentioned that, Scott. California people, you can close your ears. That is not the rule in California. But in Colorado, the department has come out strongly with that directive that that there can't be a dollar cap. So thank you, Scott, for reminding us. So here's another one for you, Scott. In Colorado, how long, well, first the question was, how long can the insurer sit on a dispute over the replacement cost of the home? So if the policyholder says, we've got an estimate that says it's X and the insurer is saying it's 30% lower Y, and they're working on it, how long can the carrier sit on it?
Well, that's a good question and a very difficult position for a policyholder, because the longer the carrier drags this out, the closer they get to their 12-month or 24-month ALE limits. And as long as you're under policy limits and you have presented your claim, that, I didn't hear much about that previously, but it's the policyholder's duty to present their claim to the insurance company. And you need to do that through a legitimate contractor that's prepared an estimate of damages, or through a public adjuster or some other way to get it in front of them that they are low and they're lowballing you. So if you're within policy limits and your estimate still has a 30% gap, bad faith, insurance fraud, probably. There's nothing you can do to accelerate the process except file a complaint with the Division of Insurance and anticipate that you'll get an answer based on your ALE. That's the key. It's based on your ALE, and time limit is running out.
Natasha, did you want to add as far as anything to do to accelerate the stalemate?
Very much what Scott just said. Go ahead, get an estimate or a rebuild contract if you're already in the process. The other thing I do, and carriers do oblige, is I want their ESX file. As soon as you ask, they know. I retain someone to prepare exactimate, so we're speaking their language. So go ahead, ask for the ESX file, because that will have the detail. I mean, Denise said it so succinctly. Nobody builds a house room by room. It's kind of a crazy way, but there are people skilled so that we're speaking the same language. The software flaw of Xactimate is a whole different discussion. The minute you ask for that ESX file and they know they're coming under scrutiny, and if you can go through it, even as a lawyer who knows now more than I wanted to about construction, up here, the code requires 2x6 framing. If your Xactimate showed 2x4s instead of 2x6s, or it showed a stick built home and you had a log home, if you can highlight maybe a dozen or two of the gross errors, and there are always gross errors. Sometimes they forget to add any kitchen appliances. Highlight those, make them go back, but I'm with Scott. Give them an estimate, a rebuild contractor, and Xactimate.
Yep. Okay. Waiving inventory requirements. This is a question that's a classic that it's so onerous having to do the inventory, and they're looking to try to shortcut or at least reduce the stress. So does it make sense to offer to settle for less than our maximum if they're willing to waive the itemization requirement? So this is obviously a very personal decision. When we were trying to figure out in the legislation negotiations and with Colorado Commissioner Conway, how high we could get insurers in terms of what they have to automatically pay. He went to see what they typically pay. What percentage of an inventory do they typically pay? It came out somewhere around 85. And so we that's how we got there was negotiations down to the 65. And so I guess what I'm trying to say here is you absolutely can offer to settle for less than your maximum if that is what's going to get your family to where you need to be, back to a place of peace, back to a place where you can focus on other things in your life and put this one part of the trauma behind you. So how much less is really up to you. We know insurers are paying 60 in a lot of cases, because we just heard it from the Department of Insurance this morning during a meeting. We know that when the law is in effect, it's going to be 65, and that's just a minimum. So it really does come down. It's very similar to the underinsurance issue. What has happened on your claim to date that gives you leverage? What have they done wrong that you'd say, well, you kept me waiting on this. Let's make a deal here. Is generally how a lot of people go about this. Or, if you hear that a neighbor has gotten a payout without an itemization, you can use that. But I think the bottom line is you have nothing to lose by trying, but it has to be a number that feels right to you in your household. And then, of course, if you've gotten some progress made on your inventory, you would want to build on that. Is there anything you would want to add to that, Natasha, for Colorado?
Oh, I think Denise said it, Scott said it. I mean, whether it's a public adjuster, a law firm, we have teams that do this. I have 2 paralegals that all they do is help. And a lot of people only want help with this piece of the claim. And oh my gosh, for all of you on this call, I get it. It is so painful. It's not just stuff. It's everything that was your family history. It's hugely time consuming, especially for those that work full time. This is a part of the claim where you might want to reach out and have someone help.
Okay. Continuing ALE, how long can I continue to live and collect in an apartment? Basically, how long can I keep collecting ALE even if I've sold my lot? It should not matter if you still don't have a replacement home. So selling the lot should not matter. But obviously beyond the 24 months, you'll have a challenging argument. Do either Natasha or Scott disagree with me that selling the lot should have nothing to do with?
Correct. They're looking for a new home. It's exactly the answer as we discussed earlier. They're trying to find a house in a community. If they're Marshall Fire, where you lost 1,100 homes, it's challenging to find something to replace it with. So
Right.
I think here
selling the lot is irrelevant. It should not.
You're completely, again, the policies typically read that it's the shortest time to repair or replace or to settle elsewhere. Here they've opted to settle elsewhere. So they're well within most policy language. That's their prerogative. Scott?
Agreed.
Agreed. Okay, good. Okay, let's see. Under insurance, do I need to hire a lawyer? Let's see, let's go through this. There's a lot in this question, so we can all sort of tackle it together. Can I request appraisal? Well, yes, it doesn't matter that if you don't agree, with the amount that the insurer is paid, you can request appraisal. So that's a yes. But increasing the amount of coverage in your policy is not an appraisable issue. Appraisal is only for figuring out the amount of the damage. So you wouldn't use appraisal to try to remedy an underinsurance problem where the basic limits in the contract are not enough. If what you're trying to do is get more benefits from the insurer than what's provided in the contract, that is the classic, what kind of leverage do you have? What are the facts and circumstances that led to your limits being set? And do you have any evidence that either the agent who sold you the policy or the insurer made any kind of express representations to you that it was adequate? And did you, if they made recommendations to you to increase your coverage, did you do that? All the things that we go through in the underinsurance section of our website. This is not an appraisal issue. Now, if you've gotten an estimate to rebuild your house that is within your policy limits, and the insurer has gotten an estimate that's also within policy limits, but it's much lower, then you could use appraisal. But if you're trying to get above policy limits, that's not the forum that you want to use. Is there anything else that anyone sees in this question that we want to add?
Yes, this is an issue near and dear to my heart. We have a large number of clients that we are helping with this right now. There are things you can do without bringing a lawsuit, and we actually have been partnering with some people to try to help them. If we can give them advice on what to do without them having to file a suit, awesome, that is great. And because we're helping them, if it turns out that the insurance company still won't budge, then they're in a really good position to bring suit. But some of the things to look at, first of all, did anyone make any misrepresentations to you about your house or your insurance? Did you specifically ask before the fire if you have enough insurance in the event of a wildfire? If you asked that and they said yes, that puts the onus on them. It's much better if you have that in writing, that you emailed it to them, but you can state that it was a verbal conversation as well. Also, did they get everything right in the application and moving forward? If you provide all correct information and they messed it up at some point so that the ongoing renewals were too low, again, that's on them. A big thing that we've been seeing is older homes. Say your house was built in the 70s and you've been insuring it with the same insurance company, we'll say Farmers, since the 70s. Well, in 2011, they switched all of their policies over to a new type of replacement cost software called 360 Value. 360 Value is actually owned by the same people who make Xactimate, and they use the information to support the other ones. So in order for 360 Value to get a correct read on your replacement value, they have to put in a ton of information, real details about your house. The problem is, most of the policies prior to that, the agents never collected that much detail. So unless they reached out to you when they flipped it over to the 360 Value estimate, they don't have any of that information, and the system defaults to the lower values. And over the course of time, your annual renewals are lower and lower and lower, and then your house burns down and you're dramatically underinsured. We mentioned the Department of Insurance market conduct reports earlier. There are at least 4 out there right now specific to wildfires against Travelers, Nationwide, CSAA, California Auto Insurance, and USAA, requiring that the insurance companies pay millions of dollars. CSAA had to pay $40 million in additional benefits because their insureds were underinsured, and it was the insurance company's fault. There are ways to get these payments. It's not easy, and it is definitely a fight, and you may very well end up needing to bring litigation, but it is doable, and there are ways that you can make the argument. So dig into it and see what arguments you may have.
100%. Couldn't have said it better myself. And thank you. All right, another one, right on the same theme. We've been paid our policy limit and expect to get additional monies as we rebuild, and that makes sense. But it won't cover the cost, so they're underinsured. So this is very much the same question, and we're gonna reference Carrie to the previous answers, that it really is fact dependent. And if you can establish, as we say on the UP website, that you were innocently underinsured through no fault of your own, that you reasonably relied on things that the insurer and agent told you about the adequacy of your policy, then you should absolutely push forward. And just know that, as Stacy said, it can be not an easy fight, but it has been won many times, almost always behind closed doors, which is why the published cases and the law look very much like they favor the insurers. But because so many people have found themselves underinsured, and there's been so much pressure put on insurance companies by our organization, by our panelists, by our partners, every day. I think I've probably done at least 6 media interviews in the last 2 weeks, publicizing the fact that so many wildfire survivors are underinsured. So the insurers are feeling the pressure for sure. And so if you can just get your ducks in order and put your best foot forward, and approach them with a reasonable proposal for them to pay above limits, it definitely can be done. But again, almost always it's going to be behind closed doors with a confidentiality agreement and no guarantees. Okay, other structures. Scott and Natasha, what are some of the common items people may not list under other structures? We often think of them as garages, outbuildings, pools, sheds, walkways, retaining walls. Is there anything left that I left off from that
Sure.
list?
Fencing or retaining walls, fire pits up here. What do you have, Scott?
Oh, I agree with you 100%. What we've been trying to do is get the Division of Insurance to write a bulletin that says that the other structures coverage is available if you're underinsured on your dwelling. I don't know if that is relative to this question, but it's an important addition to available coverages if that is in fact the case. And we've been working with the Division of Insurance here to try to get that put into place.
Okay. All right. Debris removal coverage, California. Let's have you hit this one, Denise.
Let's see, debris removal.
Or Stacy. I'm not sure which of you, either of you.
I
either
can
of you.
answer, but actually,
Great.
I'd be interested in hearing Denise's perspective on this because she probably works with it more than I do. It's really hard to track all the different areas, the different buckets of payment. The insurance companies do that on purpose. And my understanding is for phase 1 of debris removal, that's completely handled by the state of California. For phase 2, they will go after insurance payments, but they can't ask you to pay more than the insurance coverage was. So if you had 5%, then that's all. Even if they chose to pay you more than that, I don't think they can ask for more than what your policy would have covered. Denise, have you run into this before?
I actually did for the Woolsey fire when they started these programs for debris removal. I have run into this. So with these programs, these state-run programs, they actually can't ask for more money than what you have under your policy. So if you have an extension for debris removal, let's say it's an extra $15,000 above your policy limit, they can't go beyond that $15,000. Usually they have gone straight to the carrier for it. We've notified them in writing. I think there's a form online to fill out, notify them in writing that, yes, we want to go do your debris removal because it costs less. and they will actually bill the carrier straight from that. I've had a couple of inquiries to my clients after the fact asking for money, and each time we referred them back to the carrier and it's taking care of the issue.
Thank you. Okay, let's see, this is Colorado. Best way to get a fair valuation or destroyed home without signing a building contract. This is a service that public adjusters will do for their clients, getting an estimate. But we also, the other option, if you are not working with a PA, is to get an estimator to do that, to prepare a document that can be compared apples to apples with the insurance company's estimate, ideally. It's hard to get a builder to do this for free. So there are some people that will do it either, on a flat fee basis. And then also we have a lot of suggestions on our website for sources, free sources of information, just like you're identifying here, of say, from the, if you can get the assessor's information about your property, etc., and Google Earth and different ways to gather the information that allows you to put something together. But at the end of the day, you need a construction estimator somehow if you can't get a builder. Scott, anything you want to add to that?
Well, that's a very good explanation. If you go to United Policyholders Ask the Expert, there are quite a few answers regarding proper valuation without hiring a public adjuster and without signing a building contract. Insurance companies are pushing for a signed building contract before they'll agree to pay the claim, but that's not required under the policy. Don't get bamboozled by a comment from your adjuster saying that we're not going to pay RCV unless you sign a building contract. My biggest question is, how is the insurance company's RCV calculation done? And can you give that to a contractor and say, hey, is this realistic, or is it going to cost me more than this? You shouldn't have to sign a contract to get your claim settled.
Agreed.
And other quick sources, Amy, you said the assessors, a lot of people with the interest rates when they were low had recently done
Refi.
bank appraisal. So that's really helpful. So yeah, I think there's lots of other pieces of information out there that can be used.
Yeah. Yes. So either Denise or Stacy, and we do have, by the way, on the FAIR plan, California FAIR plan, that's our insurer of last resort here in the state. We did a whole webinar on the FAIR plan and their claim process that you may want to watch, but it should be the same as it is with any replacement. If you have replacement value coverage and you opted for that with the FAIR plan, hopefully you did, then once you establish proof that you've spent more than what they have advanced to date, they should pay the difference. Is there any difference, Stacy or Denise, if it's a FAIR plan policy or a manufactured home?
No.
So, yeah, go ahead. Sorry.
Oh, go ahead. Sorry. The short answer is it shouldn't be.
Stacey's absolutely right. There's one of the things that I saw, the header for this is under underinsurance. If it's underinsurance and you don't have enough insurance, then absolutely they should be paying the rest of the depreciation back as soon as you're done with the home. But then there is one caveat. And I'm trying to figure out, because they put that fact that they had a manufactured home, that there may be a different issue. The carrier insures you only for your building. They insure you for the property that's on top of the land. They don't insure you for the land. So if you've got a house in Malibu versus a house in South Central, the property values for the land are quite different. So if you're putting the same manufactured home from one to another, it actually may impact your depreciation and whether or not you get the holdback. That's the one rare if you're not spending the same amount of money that you would have or should have or given. That's why I saw the manufactured home. I wasn't sure if someone was eyeing that they weren't spending the entire amount.
Right,
So,
right. Okay, Carrie in Colorado, her insurer is threatening to cut her ALE off. Oh boy, this is quite, let's see. Natasha, did you take a look at this in advance?
I did, and this is a doozy of a question. Clearly, again, you're entitled to ALE for the time it takes you to rebuild or replace your home, or when your benefits lapse, the earliest of those three. In terms of what's going on here with the remediation company, it's troubling. It would be hard to speak on this without seeing the contract, but it would seem very odd that the remediation company is not following the standard steps. I would be speaking out of line without reading the contract.
It's okay, you know, if the question requires a deeper review, it's okay to say that.
Yeah, and I'm so sorry. I mean, here's someone who
No,
has
it's,
so
I
much on
know,
their plate.
I know, it's.
And I kind of
awful.
agree you wouldn't hand over money to this company. This is a little more nuanced, again, not understanding what she and the restoration company agreed to, but the practices I see from most reputable remediation companies, yes, absolutely. They give you an inventory. I'm not sure here why they're asking for more money and kind of holding her hostage on proceeding with the work. I mean, Scott, your take on this?
Exactly the same, Natasha. This is the first time I've seen this question, but I'm baffled as to why Carrie can't get the answers to the questions she's asking. It just doesn't make sense to me, but it's a complex question that may require, further investigation.
Yeah, I'm gonna
In her
say,
situation with cancer, I mean, obviously there are VOCs, these are known carcinogens. The house has to be cleaned. But this is this is more of a contract question that I can't answer knowing without.
Agreed.
Yeah.
Agreed.
I
Okay.
will say I've actually had a similar case, and where the insured had cancer and needed to have her belongings replaced instead of cleaned, and the insurance company absolutely refused. It's not part of the policy. It's not a requirement under the policy. And we ended up having to go to litigation and eventually got a settlement over it. But that's not something that they're likely to easily budge on.
okay. So Denise, this is a California question where looks like the person has still some code upgrade money available to them. Their rebuild has gone over the original estimate, and they have submitted those invoices and receipts, and this person is stuck. So I think, I mean, if I'm reading this right, this is sort of a delay problem.
right, it looks like, well, in California, code upgrades, law and ordinance is paid as it is incurred. When we use the meaning of incurred as in if you're required to do it by maybe a governmental authority, building permits, building safety comes out and requests that a change is made under law and ordinance, or if you've actually expended the money. So I think what needs to happen, it looks like here that you actually haven't spent the money for the actual law and ordinance, but you've spent the rest of the money on the building. If you either expend the money on law and ordinance, or you have someone from the building department issue notices that the code upgrades need to occur, that's when it invokes the payment of the money for the carrier.
Yep. Okay. Another code upgrade question. And one of the reasons that UP has a sample code, building code estimate broken out is to show you that even though it doesn't seem fair that the burden becomes on you, the policyholder, to establish what upgrades that you're having to make to your project because you need to comply with the local laws, very often you do have, that burden does fall on you as the homeowner, and the adjuster leaves it out. It's sort of a classic problem. So let's go to either of you, Denise or Stacy. I think in California, on how do you document code upgrades for your clients, and how can people do it on their own?
I actually think this is a very similar answer to what the last question would be. For our clients, when they need code upgrades, what we do is we actually call out building and safety or people for the permitting process, and we have them write the changes that are required, and then we take those requests and actually submit it to the carrier. That's probably the easiest way to get your code upgrade.
Okay.
I think that's exactly right.
Thank you. All right, Stacy, and I think we've gone completely off of my assignments here. Was this one assigned to you?
It wasn't, but I can read it and answer it real quick.
That's okay. If Denise, if
I
you
think
have
it was
prepped, if Denise, if you prepped on this one,
I was on the last one, but I can certainly jump in here. Let's see what
that's
they have.
fine. Both of you, if just this is meaty.
Yes, with this one, I think this one was mine. I was wrong. That there's no requirement that you have to correct the estimate by a certain time. I'm not sure where that argument from the insurance company is coming from. So that piece of it does not make any sense to me. I don't know what she's talking about, saying that the adjuster is refusing to let her correct. The adjuster sounds like it's trying to pull a fast one on her. However, I will say that where you didn't hire a contractor to review it because they're so busy, which I completely get, you are going to need a contractor to go back and forth with them and explain why they're wrong, because the simple truth is they're not going to listen to you. They're going to say you don't know what you're talking about because you're not in the trades. So you need to have someone who is a licensed contractor, which is ironic because most of the adjusters do this themselves and they're not licensed contractors. But working on this, you are going to want to have someone who has your back and is trained, and that they will listen to point out all the errors and demonstrate what it will actually cost. It's difficult to do this otherwise. And given all the things on your plate, I would honestly encourage getting a public adjuster if it's something that you're open to, because you're dealing with health issues and trying to bounce back after a horrible, horrible disaster. And it's okay to be focused on your other issues and not want to have to deal with this as well.
Yeah, and it's never really too late to hire a public adjuster, except that if you've collected almost all the money that's available in that policy, it can be very difficult to make it feasible, financially feasible for PA to take it. But if you are still, and in that way, it might end up, you might end up having to go with a lawyer instead. If somebody would be willing to help you on a contingent fee basis, if they feel like there's some bad faith and something, for them to go on. But for sure, Linda, if you're listening, it does seem like you need some professional help. And if you haven't sought some help from the Department of Insurance, you could always do that to see how much they might be able to get this back on track before you go and figure out how to pay somebody to help you.
And I think it's also important to stress that it's never too late to supplement a claim.
Right.
You can always supplement, you can change. If you see there's something wrong, go back and bring that to the attention of the carrier, but do it in writing.
Yeah, same point. It ain't over until you, the policyholder, says it's over.
Right.
So, protect your rights, continue to go back to them. And sometimes you wear them down. They're trying to wear you down, but don't let that happen. You wear them down.
Yep. This is this next one from Bonnie in Colorado. This is a bit mysterious. The adjuster put $0 on their personal property. This sounds like a straightforward, complete violation of the law and the regulations. So maybe there's something else to this that we're not seeing?
Amy, this is what I'm seeing again and again. Marshall East Troublesome dozens and dozens and dozens of times over. So if they disagree, let's say you put new, but State Farm only accepts new as being a few months, or they want to know the source, or they think it's a duplicate, they just randomly and ruthlessly put $0 on. That is, again, where whether it's a public adjuster, one of the teams from the attorneys, or some other third-party contractors, is to really go through. This is a practice I see, unfortunately, with State Farm very frequently, almost on every single inventory. If they disagree, they'll just put a 0. And don't forget, State Farm has now spun off their contents team. Now it's the contents collaboration team. It's its own entity that inputs the data that you submit on your, hopefully, spreadsheet. Because if you put it in the State Farm program, you don't have an inventory of what you've submitted. And in order to be expedient, I had a client who had some very unique designer lamps. So he had 3 lamps by the designer in great detail on size. And what came out on the contents claim was exactly what she put in. It was zeros. They put in 3 Lamus, Lamus. So, but then what was hilarious is CCT then made up a fake lifespan for the fake thing and gave it a fake depreciation. So those zeros, I call them placeholders. They just require a bit of pushback. That's really quick, easy things to swat down in your contents.
Thank you. Okay, Denise, this question from Karka in California. It sounds like a straightforward, the valuation, either a valuation dispute and or there hasn't been a dollar amount settled from these 3. She's got 3 different contracts, different bids. And so, as Scott said a few minutes ago, you can always submit supplemental claims. And certainly if you still have money available in the policy, as long as you can establish that you've spent more than what the insurer has paid, then you should be entitled to more funds.
Right. My suggestion to Karka is that she go ahead and get an actual bid that is done in Xactivate. I know that that's most likely the fact that she's got 3 other bids. And if they're not in Xactivate format, the carrier sometimes will balk at it. And the fact that having a verbal bid is just not going to do you any good. So my suggestion, if it were my home and my garage and I wanted it rebuilt, I would go ahead and just get a estimate done in Xactivate. And if they need sub builds for framing or whatever, your contractor will do that. I think there is one other question there, whether or not you're obligated to rebuild. Well, you can adjust that claim and get that finished. Whether or not you choose to rebuild will actually be on you, and it's your decision. It might be something, if your house carries a mortgage, you might want to talk to your mortgage company because they have an interest in you rebuilding what was on your property due to value. Yeah,
but if you don't rebuild the garage, then it's going to be, you're pretty much stuck with whatever dollar amount you agreed on with the insurer, or they agreed was the value.
Correct.
Of the project. Okay. Partial loss questions, Stacy.
Yes, there is a strategy for this. What we've been doing, and we actually have a few cases where this has come up right now, when we have underinsured people and we're arguing with the insurance company, much of the cleanup that needs to be done for burned brush and trees is required by the county. That makes it a code upgrade as far as I'm concerned. These aren't, oh, we just need to plant some more pretty trees. You have erosion control requirements, mitigation requirements, all of that has to be done. And if you own, let's say you're on a house that has land. I have a client with 5 acres. It's $500,000 to comply with this. Obviously, their landscaping policy allowance didn't cover a tiny bit of that. And the insurance company is arguing that that's not their problem. Well, they're the insurance company, it is their problem. And if they didn't understand what the erosion what the erosion requirements are, the county codes, that's on them. So yes, there are ways.
Sorry, I did not mean to
It's okay.
distract from your answer. Little technical difficulty as we get on. All right, well, listen, this has been a marathon. Thank you so much to our panelists. We have just a few informational slides we're going to go through. We got through a tremendous amount of information tonight. Please, if you were impacted by the California 2020 wildfires, please take our recovery survey. That link at the top will take you to it. Really helps us do our job to be your advocates and to be your sources of information. You will get entered into a drawing to win a $50 Amazon gift card. If you were impacted by the 2021 wildfires, we also have a survey for you that we want you to take. These are just for California folks. We just wrapped up our 6-month Marshall survey. We'll be hitting you again at the end of the year to do a 1-year survey for Marshall, but for California, just one more nudge. 2020s, please take the California 24 survey. And if you're a 2021, please take the California 12. That's 12 months or 24 months. Stay connected with other survivors through our forums. Use our Ask an Expert forum if you did not get a question answered tonight. Reminder for the free help that's available through your California department, toll-free number, your Colorado department, limited free pressure to be brought on your insurer by your state regulator. I want to thank our funders in California that are making it possible for us to bring you this series. Our Colorado funders, we're so grateful to, but most importantly, we're grateful to all of you for giving us your time and giving us the opportunity to help you on your journey. And then, of course, my team, my amazing team, and my amazing panel tonight. Denise, Stacy, Natasha, Scott, jumping in. Thank you all so much. I know your expertise is very valuable and to your clients, and thank you for sharing it with us and our audience tonight. I wish you all a safe and peaceful evening until we next are together. Thank you.
Thank you so much.
Thank you.